Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Thank you, Madam Clerk. Good morning, everyone. This is day 2 of our February session of the Court of Criminal Appeals here in Knoxville. My name is Robert Wiedemeyer. I live in Nashville. To my right, our presiding judge, Camille McMullen, who lives in Memphis, from Memphis, and to my left, Judge Timothy L. Easter, who is from Williamson County in Middle Tennessee. We have read the briefs on the cases. This is primarily for the attorneys who, if you've been here before, you know what the drill is. But we've read the briefs. The records are here to be assigned later. Each side gets 20 minutes to argue their case. If the appellant wishes to reserve some rebuttal time, if you'll please announce that when you come to the podium. The clerk will program that into the light that tells you when your time is about to expire, and I'll also try to help keep up with the time as well. Are there any preliminary matters on the docket?
No, Your Honor.
All right, I believe we have 3 cases. If you'll call the first case, we'll get started.
State of Tennessee versus Justin McDowell.
Good morning.
Good morning.
Are you Ms. Moore?
I am.
All right, proceed.
May it please the court, I'd like to reserve 5 minutes for rebuttal.
5 minutes, certainly.
Where there is a right, there must be a remedy. In this case, the Tennessee legislature has vested a right to those previously sentenced under the old Drug-Free Zone Act to move for resentencing under the new provisions. They have vested that right. This is not an absolute. Not everyone has the right to be resentenced, but they have the right to move to seek resentencing. And then the lower court must analyze the facts of the case and make an individual determination. The problem with this, or the problem with a lack of appellate review, is that courts are applying this statute differently. Because this is an abuse of discretion statute, they have discretion as to how they want to apply it. However, where this right is dependent upon the jurisdiction from which your sentence arises, or within Knox County, which division of criminal court your sentence was imposed, it creates the unequal application of this right. And so the remedy must be appellate review. And I acknowledge that various panels of this court have declined to extend appellate jurisdiction on this matter. However, frankly and respectfully, I think and I hope that you all have been wrong. I think that I was always taught that in the law, every word, every punctuation mark, every capital letter has a meaning, has importance. And in Rule 3B, the drafters of the rule of the Tennessee Rules of Appellate Procedure, Rule 3B, the drafters chose to draft the provision with the lowercase letters for post-conviction proceedings, rather than the language included in Tennessee Code Annotated Section 16-5-108 that has the capitalized Post-Conviction Procedures Act. Therefore, I believe that you all can and should read into the lack of capitalization to include a broader interpretation of post-conviction proceedings, in which case motions for resentencing under the amended Drug-Free Zone Act would apply. These are proceedings following a conviction, in which case Rule 3B does in fact vest appellate jurisdiction with each defendant. And I believe the State v. Watson case, in which you did find that there was jurisdiction when the motion was granted should also support this, because a distinction would, in those that received relief and those that didn't, would further exacerbate some miscarriage of justice, some unequal application of the law. So, with that said, I will move on to the merits of the argument, because I believe that in Mr. McDowell's case, you all are in the unique position. As the state noted in their brief, Mr. McDowell had 2 cases that were appealed, one of which was granted. He was granted relief, excuse me. In that case, he went to trial. He received a drug-free zone enhanced sentence on an A felony. In following that trial, he entered a plea on this case. That plea saved the state time, money, resources. It was a benefit to both parties. Following the amended statute, or the amendment of the drug-free zone statute, the benefit for which Mr. McDowell bargained was not as great. The facts and the circumstances changed. The positions of the parties changed. The negotiations for which Mr. McDowell entered into prior to the amended statute, the facts and circumstances changed. And if he had negotiated his plea without the threat of the drug-free zone enhancement, then things would have been different, because his sentence was enhanced by the old drug-free zone statute. So this change in law created a change in circumstances which altered the benefit of the bargain for which he entered previously. And to deny him the right to appeal the trial court's abuse of discretion in denying him relief on this would be to ignore this change in circumstances, would be to ignore the fundamentals of plea bargaining, for which defendants must be encouraged to engage in, considering the overpopulation of courts and overextension of every court in Tennessee at this time.
Ms. Moore, can I ask you a question? You are arguing here this morning that under Rule 3B, we do not have the authority to hear this, and you've indicated, I believe, that you think we should hear it as a post-conviction matter, because we obviously have the right to hear post-convictions.
Right.
Your brief seems to me to indicate that you want us to hear it, that you're seeking review under the theory of a writ of certiorari.
I am arguing that the Rule 3B language does not limit post-conviction proceedings to those filed under the Post-Convictions Procedures Act. So it is a more encompassing phrase due to the lack of capitalization. It is.
Did you argue that in your brief?
I believe so. Well,
okay.
Yes, I did.
Okay.
And then as a fallback, if the court did not see things my way, then I think review is appropriate under the writ of certiorari, because this is a plain and palpable abuse of discretion.
And you are aware that we have taken these cases under the when one is seeking review under a writ of certiorari. We've taken these resentencing cases.
I read your opinion this morning, so
Okay.
I am aware.
Well, it's a fairly new concept, I think, but I mean, it's clear from our Bobo decision that there is no right of appeal under 3B for these.
Well, and that's where I hope that the Tennessee Supreme Court disagrees with you. But yes, I believe that Mr. McDowell's case is distinguishable from State v. Potee. Is that how you pronounce it?
Your guess is as good
Okay.
as mine.
Because the trial court in Mr. McDowell's case did determine that he had met the threshold issue of the new drug-free zone statute not applying to his case as it is, because it was either outside of the 500 feet or it did not expose vulnerable people to the dangers of drug-free zone. So we met that threshold issue, whereas Potee did not, where where the court found that Mr. McDowell was not entitled to relief was first the failure to prove that he would receive a shorter period of confinement because 5 is less than 6. But in that analysis, the court ignored the realities of the service rate. So 5 at 100% is going to be a longer period of confinement than 6 at 35% due to the sentence reduction credits that are available to a person serving a sentence at a 35% service rate versus those serving a 100% service rate as dictated by Tennessee Code Annotated 40-35-501. So I think that the court conflated the length of sentence and the period of confinement in a way that was improper. And had the court considered the actual period of confinement, Mr. McDowell would be subject to a lesser period of confinement. Another distinction is that while the lower court noted in this case that Mr. McDowell's criminal record precluded him from relief under the interest of justice factor, as the state noted, Mr. McDowell, the exact same man with the exact same criminal history, was entitled to relief on the case for which he went to trial. So if the interest of justice did not dictate denial in that situation, then how could it possibly dictate denial in this situation?
In the case that went to trial and he was sentenced on and then ultimately, I guess, re-sentenced, was he sentenced as a range 2 multiple offender, which he absolutely is?
Yes.
Do you not see that as a distinction here? Because here he was allowed to plea as a standard offender, as I understand, when he, in all actuality, was at least a range 2 offender.
Well, and I guess in that regard, it goes back to the, I don't want to insult the legislatures, but poor drafting, the vagueness of the statute, because they do not.
Which statute?
I'm sorry, the amended drug-free zone statute.
Okay.
Because under subsection H, they do not define whether a person who pled guilty would be resentenced under the same terms as a range 1 offender, or if they would have to be resentenced as their actual range. So.
But you do agree, he certainly got the benefit of the bargain in the plea agreement.
I would disagree. I think he had a minuscule amount of cocaine, and it was possible that, and very little money on him. And it was possible that had we gone to trial, we could have.
But he didn't. He chose to plead guilty and be sentenced as a range 1 offender when he absolutely was not a range 1 offender.
Correct. And I believe it's in the record that he was initially charged with two various theories and 2 drug-free zones, so his sentence could have been significantly worse had he gone to trial. But he did not go to trial. He saved the state that time. He saved himself that time. And another factor in that regard is that had he just waited to plead guilty a few months, had his attorney been a little more up to date on what the legislature was doing, then she could have saved him time by just delaying until the amendment took effect, and then he'd be sentenced under the new law. The act wouldn't have applied. So that, plus COVID, kind of cost him the benefit that he could have received by just delaying things for a bit. So I think that while in 2020 this was a much greater benefit, at this point in time under the new law, the lower court could have resentenced him to 5 years at 30% within the terms of the plea agreement. He'd be sentenced to 5 years as a range 1 offender. Or the court could have resentenced him to 6 at 35%. And that still would have been a shorter period of confinement. Unfortunately, due to the vagueness of the statute, it's not clear whether that is permissible, but also on the flip side of that coin, the statute does not preclude the trial court from resentencing him under the terms of the plea agreement as a range 1 offender with a 5 years to serve sentence. So we would ask that this court find that there is jurisdiction and remand the case to the lower court to be sentenced within the terms of the plea agreement, but without the drug-free zone enhancement. Thank you.
All right, thank you. General?
May it please the court, Catherine Redding on behalf of the state. This court must dismiss the defendant's appeal for lack of jurisdiction. It is clear under Bobo that the defendant does not have an appeal as of right, either under the statute or under Tennessee Rule of Appellate Procedure 3B. The defendant has raised several counter arguments to Bobo's findings and basically the concept of no right of appeal under Rule 3B. And I'll rely on my brief for most of them, except to point out that this is not a post-conviction matter. This case is jurisdiction over other cases or proceedings arising out of a criminal appeal also does not independently authorize a right of appeal under Rule 3B. And as to Watson, this case is distinguishable from Watson. In Watson, the defendant filed a motion to have his sentence reconsidered. The trial court granted relief, and with that grant of relief, the defendant had a new sentence, and that triggered the right of appeal under 3B. But here, as in the vast majority of the cases that have come before this court, the defendant's request for resentencing was denied, and that denial means that he does not have a right of appeal under the statute or under 3B. And contrary to the assertion that the defendant raises in his brief, the trial court's order denying resentencing does not present one of the very limited circumstances in which a petition for writ of cert or a writ of cert should be employed. The trial court did not commit a fundamental illegality. The court held a hearing on the resentencing petition, considered the factors for resentencing as are set forth in the statute, made findings consistent with the record, and denied the request for resentencing. The trial court did not deny the defendant his day in court, did not issue a decision beyond its authority, and did not palpably abuse its discretion.
So based on what you are arguing right now, it sounds like on behalf of the state, you're not suggesting that we should not grant the defendant's request to review this under a writ of certiorari, but they certainly, in your argument, you're arguing that he's not entitled to our actually granting him the remedy of a writ. But as far as just reviewing it, to get him here, to get around this 3B problem, it doesn't sound like the state is pushing back on some of our recent opinions that say we can at least grant the request to seek the review as a writ. Does that make sense?
I think that the writ of cert is the only avenue available to a defendant. But it's the state's position that just because that is an available mechanism to get appellate review does not mean that it's an appropriate one in every case, because it's an extraordinary.
Extremely.
Yes. So it's the state's position that a writ would be the appropriate way, but is not going to be appropriate in all cases. And that is backed up by the Cates law that, this is extraordinary appeal. It does not grant a right of appeal just via a different mechanism. And in this particular case, this defendant here is not entitled to a writ because the limited circumstances that have to be established in order for this court to grant a writ do not exist. Simply a claim that the trial court abused its discretion, that is a merits argument. It's a challenge to the intrinsic correctness of the trial court's ruling. And it is well established that that is not enough to justify the grant of a writ.
Oh, so. Absolutely. But I guess, again, just to get us to look at it, the defendant is asking us to review this as a writ, and then at the end of the day, we may very well say, as we did in the recent two cases, we're not going to grant you a writ of cert because you haven't met the requirements of the law.
I believe that that is correct, but I do not believe that this court needs to get there because here the circumstances do not justify the extraordinary relief of a writ.
General,
yes.
Let me ask you a question. You have written, or someone in your office has written an excellent brief on this case, which I read, And Ms. Moore's brief was excellent also. And we've been discussing all these, the technicalities and the rules, and which is all very important. But to follow up on what Judge Easter is saying, just as a practical matter, every day in this state, we have criminal court judges, trial court judges, making sentencing decisions. And every now and then they make mistakes. Not often, because we have a great judiciary in this state, but that sometimes they make mistakes. And that's why we're here. We got into this a little bit yesterday. I mean, if errors are made, it's our job to look at the error, if it's a serious error, and then we correct the error. So we have this drug-free zone issue that for years and years the penalties were greatly enhanced. Then the legislature said, we're going to change that, and we're going to let a lot of these folks have a shot at getting their sentences changed, and that goes along. But occasionally, the trial judge that looks at it again is going to potentially make a mistake. Whether that's true or not in this case, I don't know, but it seems to me, I'm not quite following that it's fundamentally fair for then the defendant not to get us, the Court of Criminal Appeals, have a chance to review it. And like Judge Easter said, that we may find that there's no merit to it. But what I kind of hear you saying about this case, and you may be absolutely correct, you're talking about what happened on this particular case and basically saying in the state's view, there's no merit to additional relief. And I respect your opinion on that, but the way it's supposed to work, in my opinion, is the judge at the trial level decides something, and then whether there's merit to it or not is what we look at. So to circle back around, and I'm sorry to be so wordy here, but if you circle back around to, all right, we have a defendant, he asked for some relief, it was denied by a judge, that judge's work gets reviewed or should get reviewed by 3 judges here, but there's no way to get from that judge to us under Rule 3, if I agree with you on that. Doesn't that kind of fit pretty nicely into this cert argument of, well, there's no other remedy, so how can it be fair to this defendant? There's no other way for him to get us to look at what this judge did, the trial judge did, to see if there was an error or not an error. To me, that kind of fits in pretty appropriately. Now, I know you're using the word extraordinary and abuse of discretion, but I think the way I read the brief, one of the deals is just basically there's no other remedy available. So I'm just wondering what you would say about that part of the certiorari argument. She's saying, basically what I hear her saying is, I don't really care how you do it, but get it up here so you 3 judges can look at what this judge did and tell us if it was fair or not.
Sure. Well, I'd say that the resentencing under the amendments to the Drug-Free Zone Act is a creature of statute. Had the legislature intended for a denial to be reviewed and the merits of the denial to be reviewed, they could have included that in the statute. But because they did not, then we are left with Rule 3B of the Tennessee Rule of Appellate Procedure. Obviously, as this court found in Bobo, that does not provide an avenue. So then when we get to the writ of cert, I agree that there is no other way for a defendant to get before this court, but even still, the limitations that are put in on a writ of cert still exist. I mean, there is case law that says that it is not available as of right. It's only to be granted under unusual or extraordinary circumstances. It talks about it can be used to correct fundamentally illegal rulings. And so I'm not asking this court to engage in the merits and say, well, the merits, here the defendant really wouldn't be entitled to relief because the trial court acted within its discretion and thus a writ is not required, because that gets down to another level. What I think the inquiry in deciding whether to grant a writ of cert is to look at overall the nature of the defendant's claim. And here the claim is simply the trial court abused its discretion in kind of analyzing the factors. This is not, kind of have to look at what kind of error, not necessarily the merits of the error, but what kind of error is being alleged, and determine whether it is, whether a denial, when you look at it's a little interwoven, but look at kind of what exactly the defendant is alleging. Is the defendant alleging a fundamental illegality? No, the defendant is alleging an abuse of discretion. And those are different levels of error or potential error. And because of the limitations that are put in on a writ of cert, I mean, it is not, just because the defendant, unfortunately, is not provided with another avenue of appeal does not mean that the kind of high standards for granting a writ of cert can be reduced simply by virtue of the fact that there is no other way to get here. Those limitations on extraordinary, unusual still exist, and the legislature can look at, what is left to defendants and change his mind and make another amendment to the Drug-Free Zone Act. But simply by virtue of the fact that a writ is the only avenue left to a defendant doesn't mean that kind of the well-established kind of limitations on when that's appropriate should be reduced. And
but you do agree, if we do grant the request to review this as a cert or a writ of cert, that the way we look at those is completely different from even an abuse of discretion. It's a much higher bar. It has to be, that the trial judge acted illegally. I mean, that's pretty high bar.
Yes.
So I had another thought. I was going to ask you, are you aware of any other procedure in a trial court, particularly when it comes to sentencing, that does not have an avenue of an appeal other than this one? I know you probably weren't prepared for that.
I was not prepared for that.
But I mean, in my mind, I can't think of anything else, particularly when it comes to sentencing, that the defendant petitioner doesn't have an avenue to at least have a review of that.
I'd have to think on that, but I think the distinction between what kind of resentencing issue we have here. I mean, we have defendants who their judgments have become final, I mean, in some cases many years ago. Mm-hmm. And so we have just an avenue that has been opened to defendants whose judgments have become final long ago to then seek additional relief now that the rules have changed.
But even if they allege something that's beyond, say, a statute of limitations, we still have a right to look at the trial court's ruling on that, do we not?
I believe so.
I think so.
Yes.
But are you arguing, and I know this is really dangerous for any of us, but are you arguing that the legislature intentionally left this avenue of appeal out in this resentencing statute? They intentionally did that?
I believe the case law that deals with statutes says that the legislature is presumed to realize the effect of their drafting. And given how this statute is drafted, it does appear that the legislature intended to limit the avenue for appellate review. I mean, Watson kind of stands for the distinction that if you are granted relief, you have a new sentence and you now have a right of appeal. But I think that a plain reading of the statute does indicate that the legislature did not intend for defendants in this, like Mr. McDowell, who are denied resentencing, to have an avenue for further review.
I'm not going to argue with you.
You gave an excellent answer to my meandering question, by the way. I appreciate that. And I think I agree with you that I think the intent of the legislation, I realize not everything you get a chance to appeal it. But when we get into something as important as felony, or even misdemeanor for that matter, any kind of criminal sentencing where a person's, how long they stay in jail is involved, to me, just fundamentally the way the system should work is we should be able to take a look at what the trial court did. And as you know, probably 9 out of 10 times, we're not going to change what they did because there was no error made. But just the chance to take a look at it is what I guess has some concern to me. That's what I was saying.
And I think that is, I mean, the writ, in this particular case, granting a petition for a writ of cert would not be appropriate. But that's not to say that it wouldn't be appropriate in other cases. It's just that if a trial court does act in a fundamentally illegal manner, I mean, it would be entirely appropriate for this court to conduct review. But when, as here, a defendant is simply arguing that the trial court abused its discretion in denying a motion for resentencing, when it's clear from the statute that a trial court does not have to grant resentencing, that does not arise to the level. But certainly in another case with different facts and different findings by a trial court, that could be appropriate. But here it is not. Unless this court has any questions about the merits of the actual claim, the state will rely on its brief and simply ask this court to dismiss for lack of jurisdiction. Thank you.
Thank you, General. You got some rebuttal time. Ms. Moore.
A writ is extraordinary relief, and it's not appropriate in every circumstance or in every case. But I think it is in this case. As stated on page 8 of State of Tennessee versus Wayne Darrell Potee, M 2023-00179-CCA-R3-CD, the writ can be granted when the trial court demonstrated a plain and palpable abuse of discretion. And in this case, it's not simply the merits of the court's decision. It is the direct comparison of the trial court's analysis in Mr. McDowell's sentence when he went to trial versus the plea agreement sentence. And the trial court's analysis of the interests of justice in that case versus this one. Mr. McDowell is the same person, but the difference being that he pled guilty in one and not in the other. And obviously I know that there was a benefit to him pleading down a range. However, he still received the enhanced sentence, and that is why we appealed, is because the legislature created this right, and it was to correct decades of over-sentencing defendants. And Mr. McDowell was over-sentenced in this case. The 100% service rate is the error to be corrected. And while the legislative intent is deferential, and they did not specifically include a right to appeal, I don't think that precludes you all from reviewing it either under Rule 3B or under a writ of certiorari. So I would ask that the court grant it under one of those two, because as you said, I don't care how you do it, as long as you do it. So thank you very much.
I got that part right, didn't I? All right, thank you, both attorneys. The briefs are really excellent, good arguments. We'll take it under advisement. Thank you. All right, call the next case, please, Madam Clerk.
State of Tennessee versus David Lynn